Microphone. Computer.
Anita, is this? Good evening and welcome to the Avery Research Center for African American History and Culture. My name is Dr. Tamara Butler and I'm the executive director here. So I wanted to welcome you all who are here in person as well as those of you who are tuning in on our live stream on YouTube. So tonight's conversation, I'm hoping that you have your notebooks ready because it's not a spectator sport. So that you're taking some notes, and if you haven't picked up your copy, please do. And if you have your copy, hopefully it's well marked up. So I wanted to start where I usually like to start with a little bit of some words. So I like to start with some words from Audre Lorde, who is one of my favorite. So it's really based off of, I was looking through Justice Deferred, which was hand delivered to Avery not too long ago. And in it, the authors write, idea of freedom is a powerful engine. And so I've been really thinking about that and who else to help me think through this concept of freedom as being a motivator, as being a driving force for people than Audre Lorde. And so I wanted to start with her poem, a song for many movements. And so she says, nobody wants to die on the way, caught between ghosts of whiteness and the real water. None of us wants to leave our bones on the way to salvation. 3 planets to the left, a century of light years ago. Our spices are separate and particular, but our skins sing in complementary keys. At 7:45 meantime, we're telling the same stories over and over. Broken down gods survive in the crevices and mud pots of every beleaguered city, where it's obvious that there are too many bodies to cart to the ovens or the gallows, and our uses have become more important than our silence. After the fall, too many empty cases of blood to burn or bury. There will be nobody left to listen, and our labor has become more important than our silence. Our labor has become more important than our silence. And so I just think about that as I think about people who have been asking for and demanding and working towards freedom, and that we are in the 21st century still asking questions of when will justice come? What does justice look like? How might our labor have outweighed our silence? And so I ask that we turn our attention to our guests here, and I want to introduce our moderator, and I hope that we come with open minds and open hearts to imagine what might justice look like when we're no longer silent. So I wanted to introduce our moderator for tonight, Dean John White.
Thank you. Thank you. And welcome to everyone who's joining us in person and on Zoom. As Dr. Butler said, I'm John White. I'm Dean of Libraries here at the College of Charleston. And I am extremely happy to introduce our panelists tonight and the authors of Justice Deferred. Vernon Burton is a prize-winning author of several books, including The Age of Lincoln. He is the Judge Matthew J. Perry Jr., Distinguished Professor of History at Clemson University, and Emeritus University Scholar and Professor of History at the University of Illinois. Armin Derfner has been a civil rights lawyer for over 50 years. He has been counsel for, among others, the NAACP Legal Defense Fund and the Mexican American Legal Defense Fund and the Legal Defense and Educational Fund, and has helped desegregate university systems and legislatures across the South. He argued his first Supreme Court case in 1968. We're extremely happy to have our authors with us tonight. And the way we're going to run this evening is I'm going to ask our panelists some questions about the book. about how the book came to be. We invite questions from the audience at the end, and please feel free to join us, those of you on Zoom, to ask us questions over Zoom chat. We'll try to keep an eye on that as best we can. But I'm going to start tonight with my friend Vernon first, and ask you, what was it that sort of sparked this book? What were the initial conversations? How did this book come to be?
Well, as usual, it's a little complicated because Armin asked me to join him as an author after he'd been teaching a course here at the law school. But it really goes back much further. And I will say, one of the things that I have stated many times is I do not believe any historian could have written this book. And I think Armin agrees with me. We don't think any lawyer or law school professor or constitute could have either. This is a book by an attorney, a civil rights attorney, and a historian that uses the Supreme Court as a lens to look at race in America before there really is a constitution, right through the nomination process of Amy Coney Barrett in 2021. So I think that's unique. But the better backstory of this is many of us today from the civil rights community feel like we're in a crisis with the rulings of the Supreme Court in a lot of ways, but particularly in voting rights. And there was a similar crisis. And I think we can learn some lessons from that of how people addressed it. In 1980, in Mobile, Alabama, there was a court case where African Americans who were a large percentage of the population, but who could never elect the candidates of their choice because of what's known as racial bloc voting by the white community. And it had been the law, the way the Voting Rights Act was understood, that all you needed to show was several things, but one of them was that the effect of the law kept minorities from having an equal opportunity to elect candidates of choice. But the Supreme Court decided no, you had to show that the intent of those policymakers, of those politicians, was to write that law purposefully to discriminate against minorities, or in this case, African Americans. I remember some wits, it might have been the New York Times or an Alabama or a paper, who knows, but said, well, what are we going to do? Are the lawyers going to do? Are they going to dig up these people from 1911 out of the grave and ask the court, did you intend for these laws to keep African Americans from being able to elect candidates? But civil rights lawyers like the great Lachlan McDonald, my dear friend, and Armin knew that this is what historians do, that we study motivation, we study purpose and intent. And so Armin and I met in 1980, started working on a case in which Armin had been involved in for many years before that. He thought they'd won it until this came down, and then the judge reversed and said, well, no, now you have to show intent. And we really began thinking about this book, or at least the issues, talking about them, arguing about them, struggling with them in 1980. So it's been either a long process of getting this book done, or thank goodness for COVID. I have to say there's a couple of good things. I got to join my old Bible study back in Illinois with Zoom. And secondly, we didn't have anything else to do but write the book since we couldn't go anywhere, and we got it done. We outlined it about 2015 at Penn Center, is my memory. Is that yours, Armin?
Vernon's actually too modest. He talks about how we met in the Edgefield County case. That was a case that we took about 14 years to try, and we had to win it 3 times. The first time, Judge Blott ruled for us, and then it got reversed. And then pretty soon, Judge Chapman ruled for us, and then he reversed himself. And so at that point in 1980, we decided we really needed help. We got Vernon on board, and finally, that time, we won it in the Supreme Court. So I give Vernon the credit for the case.
For the coincidences of history.
Armin, could you tell us a little bit about, you touched on this, but what was the process like in writing this book? I mean, how did you write it together? Although I'm assuming because of COVID, you were separate. How did it come together? And I'm actually curious to know what my friend Vernon was like as a co-author.
Well, luckily, we were the instruments. The book was really written by two other people, Vernon's wife, Georgianne, and my wife, Mary Giles. And seriously, we did some of the writing, but they kept insisting, no, you have to write this in the English language. So what happened, actually, we live, as you know, in two different ends of the state. I'm in Charleston, Vernon's in 96. And it was really the modern miracle of the computer. So one of us would draft something and send it to the other would redraft it and change it, and went back. I bet virtually I'm sure that every single chapter and every single part of every chapter went back and forth 20 times. So if people say, well, who wrote the law part and who wrote the history part, it wasn't that. We both wrote both parts. And so I'll amplify or add to what Vernon said. A historian could not have written this and a lawyer could not have written this. In fact, two ordinary, as opposed to extraordinary, lawyers and historians couldn't have written it either. But Vernon, over the years, has become, as a practical matter, as good a lawyer as people who've gone to law school. And I count myself a historian. I actually won an undergraduate prize in my department in history. So it really is written by not just a lawyer and a historian, but a historian lawyer and a lawyer historian.
And one of the things Armand has said before, and I went back to listen, somebody who wrote that, and
Can't tell.
no, we don't know. I mean, we sort of wrote, I mean, it really was written together. Now, I will say that the better parts were cut out by Armand of this book. And then we have real arguments. I couldn't wake my wife up at 3 a.m. when we were arguing on the phone about it, but he let Georgianne have the final vote and she went with Armand every time. So when they're gone, when he's dead, I'm gonna pick up all the things of my stories they cut out, particularly things that might get us in trouble legally, and publish them after we're all gone posthumously.
The other person who deserves a lot of credit is Beatrice Burton, who is here. And seriously, because we are old-fashioned, a generation out of date. And so as far as the technical side of dealing with Microsoft Word and however you send something from one place to another, those things, we needed all the help we could get. So the technical sides of this played a huge part in the process.
There were many a time, John, it was sort of interesting. I'm working on one draft to send it, and then I get back the draft from 3 drafts before. Now, Armand, we were just, so it was that kind of work process, all done in different places. After Penn Center, I'm not even sure we had, because of COVID, we were pretty well restricted.
Right.
It was all virtual.
But also because of COVID, we had nothing else to do mostly. So we were able to get it done.
We'd worked on it quite a while before COVID, and then boom.
So Vernon, I think any historian, and I know there are a number in the room, one of the big challenges is deciding what you're actually going to use. We all, if it's a good work, a well-researched work, there are more things that we don't cite or include in any book length work than what we actually include. So I'm curious how you chose which sources to really pull from, and what were the principal, primary, and secondary sources you were able to use for the book. Could you talk a little bit about the research aspect of it? And then, after Vernon and Armand, if you could tell me, if you each approach that research maybe a little bit different and sources differently, coming to it from some somewhat different perspectives.
Well, I learned so much from Armand, of course, because I knew he was a great civil rights lawyer. We had worked together on a lot of cases. In fact, it had been sort of embarrassing when I was on the stand in Texas for the NAACP LDF and the in-person voter thing. And after my attorney got through, then Armin, who was there for somebody, stepped up, and it was like we could finish each other's sentences. He knew what needed to be said and knew how to ask it. So that was actually very helpful. But Armin was so good. So there are thousands of cases. We sort of talk about 200, but a huge number that Armin knows. Plus, he's got an extraordinary memory. So that is one of the bases. And historians have not been good about using legal records as we should. There's at least Darlene Clark Hine here is a real pioneer looking at the Texas. But we sort of think we know them. But one of the things both Armin and I discovered, there's more in those cases than even lawyers and others that we found all kind of surprises. And I like to talk about when I'm on the witness stand, what I'm doing is a totality of circumstances, which we won't get into the legal jargon, but what historians do to put things into context. And that was the way that we were also trying to do it. When you say what sources, what did we need to do? What was going on in the newspapers the day that Thurgood Marshall, in my favorite illustration by the great Cecil Williams, 13 or 14 at the time, I believe, with a camera right here, as some say the silver meteor, others say a different, but the train, he gets off the train here to argue the Briggs case. And you were asked about what goes in. Well, I found a great quote late. And Harvard was sort of fed up with our changing. You can't change anything, but the illustrations hadn't gone. So in that first illustration, there's not usually an illustration in an introduction, but there is. I put something I think that is a theme of this book, and often white people are not aware when they look at civil rights movement history, John. It was his quote about that time that sometimes I get tired of saving white people's souls. And I think that's part of what's going on. I mean, I think that says a lot about what we tried to do for this book and with this book as well. But particularly as we began to contextualize a certain case, all the things about secondary, and it's just broke my heart when so many cases and so much of our research had to get dropped out, but the book would not have filled this room, I think, in the original draft. There was so much to make it readable, but trying to follow where these cases were to put, and we learned a lot in that kind of research, I think, at least I did. And I certainly learned from Armin as he read these cases, and we discovered what rich material that was there.
I want to just add, if you look in the beginning, there's a note to the readers, I think right at the beginning of the book.
It is.
And one of the main things it says is there's a website. This is Vernon's doing. It was Vernon's idea, and he shepherded it through. There is a website that you can get to. You don't have to pay anything. You don't need to buy the book. But the website has all the footnotes, all the footnote material that we didn't have room for. If you think there's a lot of footnotes in the book, look at the website. You'll find twice as much. And that's a tribute to Vernon's, not just his use of it, but his extraordinary knowledge. I mean, he no matter what historical topic he picked up, he would know the lead 35 sources and 20 articles on the topic. So the book, as much as you say the book is well researched, and we appreciate that. It's even more than you think, and it's really that Vernon's. But I do want to add
Hours together.
I want to say one thing about the cases. Most of what I did some reading into historical sources, but obviously most of what I did was on the cases. And the research material there is the cases. And what happened is I got to read the cases. I did almost nothing but read cases. And I read the same cases over and over again. And as I read them, I would find things in the cases. And so in some of the descriptions of the cases, you'll see us take out particular quotes and hold that quote out and show how it doesn't, footnote 7 is completely contradictory to footnote 12.
In the same case.
In the same case. And also other things. For example, if you look at the end of chapter 5, okay, we're talking about the 1930s. And there were a number of different cases of different kinds. Some of the cases had to do with the new discovery of due process in criminal cases. And one of the cases was a case called Norris versus Alabama, which was really the first case in which the Supreme Court had ever set aside a conviction on the grounds of that the jury had been deliberately kept all white. Okay. There were other cases in the same period, and some of those other cases were about the white primary. And Vernon referred to Darlene, and Darlene has written the main book about the Texas white primary. And there, the Supreme Court had upheld the white primary. Well, by looking at it, looking at the cases again, it suddenly dawned on me they were decided on the same day. The Supreme Court decided. So that enabled us to end chapter 5 with a little sort of, I guess, a literary device, I would call it, saying the Supreme Court decided both these cases on the same day, with one looking forward and one looking backward. And so we came to the mid-1930s, and with the mystery, which way was the court going to go? Which I think is a nice little literary device. And I'll add one other thing. You remember from history or the movies that when Brown versus Board of Education was argued, when Briggs versus Elliott, the South Carolina version, was argued, it was argued on one side by Thurgood Marshall and others of the NAACP Legal Defense Fund, and on the other side, representing South Carolina, was John W. Davis, the Dean of Supreme Court Counsel. He had argued 140. He had argued 139 cases in the Supreme Court. This was his 140th, an all-time record, and he was requested by Jimmy Burns, his old friend, to represent South Carolina, and he was the loser. Well, going back, it turned out that both the NAACP, John W. Davis, started their Supreme Court careers 40 years earlier on the same day in the same case. In the fall of 1913, the famous grandfather clause case called Gwynn versus United States, the Oklahoma grandfather clause case. And in that case, John W. Davis, as the new Solicitor General appointed by Woodrow Wilson, argued it, and the NAACP, just formed 2 or 3 years earlier, filed an amicus brief. They were allies. So they were allies both on the day that both of them made their Supreme Court debuts, and 40 years later, they met again on the same field, but this time as opponents, with the NAACP fighting for segregation, and John W. Davis making the last stand for segregation. And that only came about because I kept reading the cases again and again, and you wouldn't know it because everybody, the NAACP brief was filed in 1913. The Gwynn case which argued by John W. Davis, decided in 1915, but by reading it, it turned out I realized that the case was argued in October 1913, which nobody would have realized because I never thought, Supreme Court case decided at least in 1 year. And so that was just a piece of irony and drama that never would have come out if we hadn't, both of us, been reading it. Sorry to go into that length.
So, no, but it's great.
I've always been struck by.
I know you need to ask questions. Let me add one other thing about what I learned in these court cases. It's always an answer growing up in 96 South Carolina. I always heard, well, you can't judge people by our standards today. They didn't know better, etc. I became a great reader of the dissents. I appreciate that, the Army. Starting, just go to it in the fugitive slave case, Prigg, with Dred Scott. It's all there. The judges that made those decisions made a choice. This becomes the theme of the book, and I should let you talk about it. But they made a choice because those people who were doing the dissents, like we think of, the great dissenter Harlan or Ruth Bader Ginsburg and now Sonia Sotomayor and others, they are explaining to their, at that time it was all rather literally, the alternative and the truth. And yet it really puts in a different light. They decide to ignore what I see as a historian as the obvious evidence. And in fact, rule for a long period, always to the disadvantage of minorities, particularly in the South with Africa, but in particular. So it's not like, I think many of us, even historians, John, had always thought, well, you can sort of explain this away because Tony didn't really know. Well, he knew because his dissenter said, you're wrong. African Americans were voting in North Carolina, a slave state, as late as 1830s. And so to say that they were never citizens and couldn't be, so they ignored that. And to me, that was, for someone who thought I knew American history, pretty eye-opening. And all of that came out of these cases as we read them. I do want to add one other thing. Armin is right. There are a lot more footnotes there, but we actually, I'm still putting up some of the text that was deleted that Armin will let me put up when he says that I didn't go too far in interpretation, is up there too. So like Slaughterhouse, there are books on Slaughterhouse. We wrote one basically, but to get it into this book, we had to bring it down. There's so much more there that can be explored. So we're putting that on the website as well. And then Armin said, well, we are putting up all these cases. How many cases do we have up there now? A lot.
On the website, full text is 150 pages.
So you can actually read for yourself. If you don't believe what we say, go read the case. It doesn't cost you. You don't have to pay the Westlaw or anyone. We have put as many cases and have continued to put as many as we can up, including these dissents, which is what I wanted to show people, that they're understanding.
Let me just underline one of the things that Bernie said. To talk about judges. One of the major themes that we have here is that judges make choices when they make decisions and write opinions. And those choices reflect their value judgments. And that's crucially important, even especially today. So when a justice decides to trash the right to vote or trash the 14th Amendment, or another justice decides to give value to those rights, those justices are making choices. And what we see, frankly, today is more justices making these awful choices, and they should not be allowed to get away with saying, oh, that's what the law is. The law has a lot of different ways to decide, and every time a judge decides a case, that judge is making a value judgment, and it's in accordance with that judge's set of values.
And it is difficult, and we tried to be as moderate as we could on this, but there's some just plain out lying. Yeah. And we
A lot of that.
Yeah, more than one would imagine on the Supreme Court, quoting things as their precedent that says just the opposite by taking words out. And it's just, and it's not just once or twice. It's, these things are, it was pretty shocking.
If you take a look at the Shelby County case, where the court in 2013 basically held the Voting Rights Act unconstitutional, they did it by inventing a doctrine called equal sovereignty. And Chief Justice Roberts, who wrote about it, actually he wrote about it in an earlier case and built on that in Shelby County. But he said, and this equal sovereignty doctrine is consistent with and was developed by this court in the South Carolina versus Katzenbach case in 1965. Then he quotes from South Carolina versus Katzenbach and leaves out the crucial words. So in the book, we have the quote that South Carolina versus Katzenbach had, and we have Robert's quote, and we show what parts he added and what parts he left out. And it turns a quote into the opposite meaning. And so we also point out that when he said there's this doctrine of equal sovereignty, we have one of the footnotes talks about all the sources, all the judges and scholars who say there is no such thing. He just invented it. And a prominent judge named Richard Posner from the Seventh Circuit in Chicago, his best line, which we quote, was, "This is a doctrine of which I had never heard, for the very simple reason that there is no such doctrine." So,
And he's hardly a liberal judge.
No, he was appointed by Ronald Reagan, a right-wing judge. Sorry to keep you.
No,
Yeah,
this
but
is great.
These are the kind of, it was exciting for us. I learned so much of what I had thought I had known. So it was fun to learn. And I hope people will have fun learning with the book. We do encourage you to look at the website too. I think some of the best stuff is there.
So this book is about race in the Supreme Court. It's national in its scope. But since we're standing here at the Avery Research Center and really the epicenter for NAACP activism in Charleston after World War II, it's home of the Progressive Democratic Party. We all came in walking the same halls that John Wrighton walked whenever he was here at Avery before he challenged segregation at the law school at USC, before he challenged segregation on public golf courses. Was there, since we're in this place, was there anything, and you've already talked about the anecdote with Davis, was there anything that you didn't know before researching the book about Charleston or South Carolina that sort of caught you by surprise? I mean, both of you are well versed in our history and our legal history, but was there anything that you learned that you didn't know before you started the book?
We didn't know, we knew all the outlines. Nothing changed in what we knew. But a lot of the detail made it so much richer. And so Vernon really dug out a lot of what Reverend Delane, who was the spark plug in the heart of Bridge versus Elliott, Vernon dug out a lot of what Reverend Delane had actually gone through. And at about the time we were writing also, Richard Gergel was writing his major book, his wonderful book called Unprecedented Courage. One example of courage, an example. And that brought out a lot of wonderful things, including the role that the case of Sergeant Isaac Woodard, that case had on forming Judge Waring's views. It's ironic. Everybody has always in town has always disputed what changed Judge Waring, because he obviously grew up as an old-time segregationist, part of the Charleston aristocracy. And some people say, well, it was a school segregation case. Some people say, no, it was that Yankee woman, that second wife. It was the town turning in. And it turns out very, very clearly, and it goes back to Ruby Cornwell. Tom Waring, we used to call him Young Tom, he's about my age, who was a relative and Tom Waring, the editor's nephew, went to Miss Cornwell and said he had not known enough about Judge Waring. Would she tell him about Judge Waring? And would she tell him things? And one of the questions was, what turned him around? And the first thing she said, this is the best explanation I've ever heard. It sounds so true. She said, it was all that sergeant's case. And we learned that in Richard's book, and we learned it in the research that we did. So we didn't change, nothing we learned changed anything, but it made what we knew and what we have tried to get across so much richer.
And I will say that, and I'm still not as convinced as everybody else is on that. There's about 10,000 pages of oral history. Am I making that up? It's 1,000 that I read through at Columbia University. About 1,000 of it seemed like 10,000. It was huge. And what he says, and I believe this, it doesn't mean it's exclusive from the Isaac Woodard case, but there have been some other things going on and better rulings before that by him. And he says the law itself, and that's one of the reasons that I can have some hope, even for a court that I don't agree with, that Judge Waring said, as I studied the law, and one of those great dissenters, Judge Harlan, the great dissenter from Kentucky, Confederate soldier, a person who held other human beings enslaved, but was a very devout Presbyterian and things. And when he does that dissent, he says, I'm racist too. I believe in it, but the law says, and I am ruling this way. And I can see that if people who claim they are originalists and believe in the text will say, well, the Second Amendment, it says very clearly we got our right to our guns. Well, don't forget there was a new covenant, the 13th and 14th and 15th Amendment, which are part of the Constitution, just as the First and Second Amendment are. And somehow people, one of the things we sort of developed there, have sort of ignored that in a way as they look around it. But I have faith that, like Judge Wary, who came to believe that the 13th and 14th and 15th Amendment were part of the Constitution as much as the first, second, and the first 10, that maybe if they are really honest with themselves, even if they don't like it, that the law can, if it doesn't change the heart, can at least be applied equally. So that's a sort of takeoff. It doesn't contradict, but I think Waring was trying to say something that oral.
So we have a comment from one of our friends joining us on Zoom. So remember to hold your microphone up so that they can hear you online as well as the folks in the room. But so I'm just sort of struck thinking about this book that, 20 years ago, whenever I was in graduate school, someone writing a book on race in the Supreme Court, would be interesting and a lot of people would come out for it, but it wouldn't be particularly controversial. But in the last few months, really in the last year or so, it seems that, a book like this suddenly can be very controversial and downright illegal, according to some of the laws being passed in a number of southern states for you to discuss a book like this at a primary school or a high school. I'm curious what the reception has been like, and if you've had anyone think of this as a particularly controversial topic, or if people have been generally positive about the reception. So I'll let Armin go first, and please remember to use the microphone.
It seems amazing to us. We think, but chapter 10, not necessarily stick to that, but chapter 10 is called Change in the Court. And it talks about what has happened in the on the Supreme Court and in the nation in the past 50 years. And one of the things it points out is that the Republican Party, which, first of all, the Republican Party took a different road after 1968. This is the party of Lincoln. In 1968, Richard Nixon became elected president using the Southern strategy, mainly with the help of Jimmy Burns and Strom Thurmond. And the Republican Party, guided by that new philosophy, held the White House for 20 out of the next 24 years and appointed something like 10 straight justices. So that by 1990, almost all the court had been appointed by Republican presidents. And it would have been ultra right-wing even before now if it had not been that a couple of those justices, say Blackmun and Stevens, turned out not to be as conservative as had been anticipated. That's one thing. The accident of who gets to appoint justices and when they get appointed. The other thing is something we don't bring as much attention to, but we do point it out. In the 1960s, this country was 80% white. By now, it is 60% white. And immigration, legal immigration, people who qualify for green cards, is 1.5 million a year, 90% non-white. Almost 1 million people a year become citizens, become naturalized citizens, 90% white. And frankly, I think part of what's going on in the country is the nature of the country is changing. And for a lot of people, that is pretty scary. So a whole bunch of these things, both in the Supreme Court, in the political situation, in the nation, bring us to a different place.
Let me get back and also give hope with this. I know Mildred Brown, who I was going to talk about some of the things we learned about. I mean, she's a legend here as well, integrating the school systems right here in Charleston and things, and all the work her father did. with the NACP. And I did learn a little bit more, even though I thought just how extraordinary those stories were. But as a historian, and you, John, are familiar with, of course, the education of Henry Adams. And one of my favorite quotes from that is that the American mind, quote, stood alone in history for the ignorance of its past. Now, he's from the Adams family. And, you know, I grew up as a Southerner and really liked Thomas Jefferson, and coming out of the yeoman white Southern class, thought that was pretty good until I discovered it's really John Adams who was worked his own farm and did these things. And one of his quotes I like a lot these days in our time of alternative facts, and this is what we're trying to do in our book and why I think it's so important, I think, going where you go. But he says, facts are stubborn things, and whatever our wishes, our inclinations, or the dictates of our passion, they cannot alter the state of facts and evidence. And that's John Adams, the second president of the United States. I guess you'd say the patriarch of the Adamses down. And I think that's what we're trying to do. That's what I do. That's what I just did for SB 202 in Georgia. Evidence matters. I cannot believe anyone doesn't want to address their history. I mean, one of the problems is, the amazing thing is, no one had a problem with the terrible, wrongly taught history we taught all these years in South Carolina. I mean, that was all a bunch of bunk. You know, Reconstruction, the tragedy of Reconstruction, the only tragedy was that it ended with an overthrow, a coup d'etat in our own state of a legitimately elected interracial Republican government, little big R Republican Party government, by terrorists. Terrorism doesn't begin in 9/11 like people think, or 9/11. It began for African Americans in South Carolina and the former Confederacy, at least until the 1965 Voting Rights Act. And we see some repercussions of that. But evidence matters. And Armin and I sort of came up with a hero that we neither one had expected, I think. Do I have time to go about it? He was talking about when the court changes. Well, I went to Princeton. Armin went to Princeton. This was before we sort of down on Woodrow Wilson now because of his views on segregation, working with the Southern Democrats here from South Carolina. But he was really somewhat of a demigod there, held up as, you know, and he was a progressive president in the sense that he's really the first one that supports labor and goes after sort of business and things to regulate them. So there is that side as well as world peace, but the other. Well, the man who ran against him for president was Charles Evan Hughes. And I always saw him as this corporate lawyer, what he was. But there was a bigger story there that we got interested in and tried to figure out why. It was Charles Evan Hughes on the Supreme Court. Until then, South Carolina says, as they did, or Arkansas or any other state, well, the laws are neutral, and therefore the courts have found it right to convict these African Americans or to deny them the ability to vote in the white primary. And Charles Evan Hughes said, you know, I'd like to see that evidence. You can see why historians like it. And that was the turnaround. He used that evidence. Now, what's interesting, this is one of those backstories I went down a rabbit hole in, but we both have sort of had fun with it since. Charles Evan Hughes' dad was an American Baptist missionary. For those of you like me, grew up in the South, there's a big difference between the American Baptist and what has become of the Southern Baptist. So there was a much closer at one time. An American Baptist or Morehouse College, for example. But he was a minister, and his son, Charles Evan Hughes, was devout American Baptist who took those values there and read them, at least in terms on race, in a way that hadn't been done before. And Armin, let you tell the story of when there was an objection and how the Supreme Court dining room got done. This gives you an idea. I could go on and on, as you can see, about somebody I've discovered and changed my mind on.
Right. We talked about
Put your mic up, Armin.
about 1935 as really a turning point. And as chapter 5 ends, we know the Supreme Court is on a knife edge. Well, chapter 6 begins in the fall of 1935 with the opening of a new Supreme Court building. The building that you all know about that the Supreme Court is in has only been there since 1935. It's the first time the Supreme Court ever had its own building. Well, so they also had a cafeteria there. Well, the building also on the front says equal justice under law. This is the new building in 1935 at a time when Jim Crow was strong throughout the country. The Supreme Court had a cafeteria for the first time ever. And the marshal of the Supreme Court came to Chief Justice Charles Evans Hughes one day and say, there are colored people trying to come into our cafeteria. Do we have to let them in? And Hughes, as you describe it, this, I have to say, this is a fourth level hearsay, but I think it's true. If it's not, it ought to be. Charles Evans Hughes takes the marshal outside and they stand there and he points up to the words and he says, you see those words? Equal justice under law? That's your answer. And so from then on, African Americans ate in the cafeteria.
He also suggested to him he might want to get another job if he could not. No, he did. If he could not agree with this.
But Hughes really is. Hughes was on the court twice. He was on the court from 1910 to 16 when he resigned to run against Woodrow Wilson for president and lost narrowly. And then he came back as Chief Justice from 1930 to 1941. And both those times, he was responsible. He wrote the opinion in just a whole bunch of landmark cases, probably more landmark cases than any other justice in history, more than Earl Warren and more than Justice Brennan and more than Thurgood Marshall. And there's an illustration of Hughes somewhere in the book, and in the caption of the illustration, it lists just half a dozen of his major cases.
So we have time for a few questions from the audience now. And if you'd like to ask a question over Zoom, please just type it in the chat. I am going to ask that once someone in the audience asks a question, give me time to repeat it so our friends online can hear the question and then before you answer. But does anyone have a question? Yes. Yeah, yes.
Wondering what was it about this background in particular that made
So the question is, what was it that made Justice Hughes such a great jurist and administrator?
I actually think it was the religious commitment, as it was, I believe, for Justice Harlan. So when we got all these people now going on the court that are so religious, I have some hope yet that God may speak to them and the truth, present the evidence to them that, like Justice Hughes, they'll look at the law as equal, people equal under the law in those kind of decisions. There may have been other reasons, and Armand thinks, but I've studied both of them, and I really, why? It's a great question. It was not a popular thing when they were doing it. And Armand will tell you that at least goes back to the question that you first asked. My image of the Supreme Court was growing up with Brown v. Board as all the good things the court did. It was sort of a shock for me as we went back to find just what a brief period that this image of a fair court doing the right thing, judging the laws fairly, we found. I don't know if you want to elaborate on that.
In a sense, we're almost trying to revive this book, in a sense, at least for me, is an attempt to revive the reality that once was. And because nowadays it's so long ago, that's how old we are, me at least. It's so long ago, it fades from memory. And one of the things that I think we have done, I mean, certainly tried to do, is to remind people that once there was a better time.
Do we have any other questions in the back?
This whole problem with gerrymandering is, I think, really, really basic to actually the survival of America. But I mean, how long can old white men gerrymander everybody else's vote out of existence? And what is the effect of doing that for the next, say, 20, 25 years?
Um, my belief, and people ask us why we have some optimism. My belief is that there are more people of goodwill than the opposite kind. More people like the people in this room than the opposite kind. A lot more. And I don't believe that a minority, even one that is able to wield the levers of power, because they happen to have them in their hands in so many states now, I don't believe that a wicked minority can prevail over a good majority in the long run. That may be faith, and I guess we'll see if it's tested. I plan to be around long enough to see the good people win.
So we have a question online, and then we'll come over here. And the question is, what is your opinion of Biden's nominee for the Supreme Court in the context of your review, a Supreme Court jurist?
I didn't hear the question.
So what is your opinion of Biden's nominee for the Supreme Court in the context of your review of Supreme Court jurist?
I think she's extraordinarily qualified. I think very lucky to have her. I think that all of his nominees were good and would pass any test. I've just been shocked, of course, to see the process. Those of you that know me know that I'm a person of faith, and I've always never really thought of people as enemies, but I've always said, forgive my enemies. But the way that the attacks in this hearing are very hard for me to understand, that we have reached a bipartisanship that is amazing. I mean, the only parallel I can think of, and we have some other historians here, is the Civil War era. And at least then it was more of a sort of regional to an extent than what we have now that's going on. I think it's very dangerous about democracy. To put it in another context, and this is taking a little bit of a leap, but what Lincoln was struggling with at the time, while a lot of people don't understand, he was willing to sign a 13th Amendment to say that slavery could still exist today in South Carolina to keep the Union together. Why did that Union matter so much to him? He didn't start out to be the great emancipator at all. That's a developmental thing as times change and things. But he had struggled his whole life with this issue. It starts with his first speech, really recorded speech, the Lyceum speech. And he just sort of redoes it until he gets it perfect, I think. And that's what you're hearing in the Gettysburg Address and the second inaugural and all the other things that we remember him for. And we forget that when the Confederacy left the Union, it is much more in line with what was happening in the world. We'd had the American Revolution, then the French Revolution, and democracies and republics are going everywhere. But we forget until you look at a musical like Les Miserables in 1830, Napoleon had taken back over, and it was now a monarchy. That Maximilian is put on the throne in Mexico, which had been a republic. That Garibaldi, who united Italy, the great freedom fighter, thinking it's going to be a democracy, what does it become? A monarchy. You're going away. And so Lincoln is struggling between this idea. His only answer was, on one side, you have anarchy, on the other, authoritarianism, and they're moving toward authoritarian. And what are we facing today? But this same issue in our own country, a move toward authoritarianism on one side, the world itself is in this. We're in that same struggle. And I fear that what we saw in this bipartisan, supposedly nomination process was an extraordinary sort of undertone of these same issues that we struggled with in 1860. And I, for one, had thought we'd decided that the reason that Lincoln believed so much in this was he saw it as the last best hope on earth, and I still do. But it is not decided yet. It's still a struggle, I think, and we saw that play out, I think, in this nomination process in a very bad way, I guess is what I would say. It really brought home to me just what the issues are at stake and issues that we thought had long been decided. I agree completely with Armin. Young people don't want to be precious, the whole generation. And Armin has pointed this out again and again, and how quickly, just in what, 10 years, have people accepted people of other sexual orientations, lesbian and gay and other, and that's accepted by people now, how quickly. And young people don't want to be prejudiced on race, and they believe in equality, I think. So that's part of our hope, don't you think, Armin? Now you can see why Armin cut all this stuff out that we had in there. So you can comment on it.
So we have time for one more question. I think you've been waiting a while, so.
Actually, a comment and a question pertaining to the comment about Charles Evans Hughes and the cafeteria. There's the anecdote in Kruger's book, Simple Justice, that Earl Warren, soon after he became Chief Justice, gave a speech somewhere in Virginia. And black chauffeur drove him off to Roanoke or Blacksburg or Richmond or somewhere. And Warren spent the night in a nice hotel and came out the next morning and realized that the chauffeur had to sleep in the car that night. It had a pretty profound impact on Warren, that he had not been able to get into a motel, even a colored motel at that time. And one other question about a what if, so there's no wrong answer. Fred Vinson, the Chief Justice, dies in September of 1953. And as I think you quote in the book, Felix Frankfurter's response when he first learns of Vinson's heart attack and shocking death, Frankfurter says, "That's the first evidence I've seen that there is a God." What if Vinson would have lived for 10 more years? Would Brown have been decided with even a 6-3 vote or 5-4 or 7-2?
Jimmy Burns stayed on the Supreme Court, right? And not that.
Right?
And remember, Earl Warren, as we also point out in the book, Earl Warren was the Attorney General of California in the early 1940s and was one of the biggest supporters of putting all the Japanese in internment camps. He was a big supporter. But yes, like Wade is wearing, he said, by becoming a judge, I learned to love the law.
Well, that seems like a good note to end on. But I do want to thank everyone for joining us tonight. I want to thank our panelists.
We do have a op-ed I want to send you, Bill, if you haven't seen it, in the Washington Post about the contingencies and the Supreme Court. Of course, our favorite one, of course, is the great, Thurgood Marshall, who said that they would have to prop him up. He wasn't going to quit, and that literally, he expected to live to 110, was it? What was it? And be shot in bed by a jealous husband and things. But this is also might give us a little hope too. But because of one thing, Justice Brennan's, who was his best friend's retirement, and then he was just so ill. And at the beginning of the campaign, when he decides to retire, it looks like that George Bush cannot possibly lose. His ratings are 80% after the first Iraq War, and Colin Powell. And then no one sees a third-party candidate of Ross Perot coming in and Bill Clinton winning. But if in fact, if he had not, as a lot of judges decided not to, if he had not retired, Bill Clinton would have made that nomination. And then Armin tell him about the rest of the politics.
Thurgood Marshall's replacement had been named by Bill Clinton instead of being Clarence Thomas. It would have been a Clinton nominee. In 2000, the decision in Bush versus Gore that gave George Bush the presidency would probably have been 5-4 the other way. Al Gore might have become president. He might have been president then. He might not have taken us into another Iraq war. And he might have been the person who appointed the next two justices when Rehnquist died and O'Connor retired, we might not have John Roberts. We might not have Sam Alito. We might have a very different world today.
It's called contingency, and it is some hope there of just how things can change. And I think we need to keep that in mind, as we move forward on all this. This Thurgood Marshall was amazing. He won almost every case he argued before the Supreme Court against all odds. No one could have bet. Then he gets on the court and he's sort of on the losing side all of those years since. It's one of the great tragedies. And I will end the story that we put in the book. It's one of my favorite. If I have time, John, just a quick one. Okay. Because it's South Carolina. You want to know about South Carolina? This is one I learned at that time. I didn't know about. The Reagan Revolution. The chair of the Judiciary Committee had been Ted Kennedy, who was superb on particularly race issues and guiding the Senate on these things. So Justice Brennan, who is small in stature, but great in mind and intellect and heart and everything else, comes rushing in his robe after they've just heard the news to Thurgood Marshall, who is not only a giant intellectually, but a giant of a man physically. And so you have this tiny little man and this huge giant. And you've got to remember that Strom Thurmond was on the Judiciary Committee, and he had given Thurgood Marshall just a horrible time for both the Supreme Court and his lower court appointments. Are you a member of the Communist NAACP? That kind of nonsense that could be done well by Strom when he wanted to for whatever reasons. And so Justice Brennan says to him, is it true? Is it true? Is it true that Strom Thurmond is now the chair of the Judiciary Committee? And Brennan, literally, this was described, but puts his arm around him, and these two great social justice giant warriors sort of go back to their chambers with the arm over Brennan. And I can just see it going back for their last battles in there. And there's something I want to remind people about contingency is this. We don't live in a parliamentarian form of government. It is a winner take all. And just because you don't like that a woman wears pantsuits, think 2 or 3 times before you decide, I'm going to write in another candidate or Mickey Mouse or somebody. It makes a difference. These Supreme Court and federal court judges are appointed for life. And as I said, it's not parliamentarian, it's winner take all for the presidency. I'll stop there.
Well, thank you. We have books for sale in the back. And thank you again, everyone, for coming.